Spanish. And the report is the result of a pressing concern, which is this gap between a growing list of international instruments and resolutions setting out standards and principles to limit the use of force, as outlined excellently by Mrs. Welsh, including also the UN guidance on less lethal weapons in law enforcement from 2020, and the lack of effective protections of citizens from arbitrary use of force in regular police operations or in the context of protests, that is, against persons who are not deprived of liberty. In this sense, a landmark report by the Special Rapporteur on Torture to the General Assembly from 2017 states that a disproportionate and necessary use of force in extracustodial settings breaches the state's obligation to prevent torture and other treatment. So to address this discrepancy, or the so-called implementation gap, the OMCT organized a briefing with the members of the UN Committee Against Torture and other high-level experts in January 2021. As a result of the briefing and also information collected through our network and litigators groups, the report outlines the main legal and institutional challenges and areas where reforms are urgently needed and on which international bodies, such as also UNODC, can and should provide clearer guidance and recommendations to states. Among the challenges identified, the report outlines, first of all, a tendency to conceive the police as a social control tool instead of a service designed to protect the community and keep them safe, especially the most vulnerable. In fact, the most vulnerable, that is racial, ethnic minorities, women, children, and other who are socially excluded or marginalized, are, as we all know, the most exposed to police abuse. In the United States of America, Black Americans and Hispanic Americans are shot and killed by police at a much higher rate than white Americans. And this applies, sadly, to any other country or many other countries in the North and the South. So to counter this trend, we need profound reforms of the policing structures and practices, and we need support of states and the international community to those reforms. A major goal of police forces should be to prioritize the consent of the public and coordination with the community over the use of force. Reforms in this direction that you all know in Northern Ireland, for instance, can remain a reference. A second challenge, and I will start closing, is the lack of accessible and comprehensive legislation on protocols on the use of force, an area with a great margin for improvement. Use of force seems to be sometimes exercised in a sort of legal vacuum. Such laws should include mediation and facilitation procedures when it comes to facilitating the exercise of the right to peaceful assembly. And they should also enshrine safeguards to make sure that the use of force is always in conformity with the 5 principles mentioned by His Excellency the Ambassador. A third challenge, and here I turn to the importance of civil society organizations and external oversight bodies, and I'm wrapping up, is the obstacles we see to the work of civil society organizations, human rights defenders, journalists covering assemblies and police interventions. In many parts of the world, CSOs are criminalized and targeted during or due to their monitoring and documentation work. In Colombia, 89 attacks have been documented in recent days now against human rights defenders following the ongoing wave of protests that has left over 52 persons allegedly killed by the police so far. So an important conclusion of the report is that civil society organizations have a key role in promoting accountable policing that should be preserved, this role. Also, of course, national preventive mechanisms have started also monitoring the use of force in extracustodial settings. And we think that this is a good practice to follow and encourage. This is the case, for example, of the preventive human rights monitoring undertaken by the Austrian Ombudsman Board that hosts a national preventive mechanism. The body monitors the application of coercive measures, including a wide array of police operations. So to wrap up, conditions to create accountable criminal justice systems and law enforcement bodies will only exist if the 3 branches of power show a resolute commitment and join efforts to implement a zero-tolerance policy to torture and ill-treatment in all circumstances, that means in custodial and also in extracustodial settings. Anti-torture policies should be adopted with direct participation of a wide array of actors, civil society organizations, communities, victims, and we welcome and thank again, in fact, today's event, as it also precisely brings together different actors. And last but not least, it is key to establish independent oversight and investigative mechanisms, which are not, of course, institutionally dependent on the law enforcement agency accused of committing the abuses. It is crucial, in fact, to name and shame the blue code of silence instead of the systematic deference that we see to the police version of the facts. So to be able to prosecute and sanction those who commit torture and ill-treatment and set up non-repetition safeguards. And here I hand the floor over to my colleague Masha Lisitsina, and I thank you very much all.
Thank you so much, Helena. And we were actually only turning off on our cameras because we thought it's nice to see someone when you speak. So you were on time, in fact. And I think you had some very important points, both on the issue of torture and on the need for legislation for institutions and independent oversight, as well as the impact of COVID measures on policing and responses. This is something that we've also been noticing and looking at in our work. So I think we're very keen to learn from you, and as was mentioned before, to have this partnership with civil society at the same time as with national institutions and independent oversight bodies. So thank you again, Helena. We'll now go to the very short presentation of a really long and important report, another one, and the links have been shared, and we can share them again to both of these reports. This one, Masha Lisitsina from the Open Society Justice Initiative will be speaking on the report that was just released. I think this is the first public presentation. It's called Who Polices the Police? The Role of Independent Agencies in Criminal Investigations of State Agents. Masha, the floor is yours.
Thank you so much, Anna, and thanks to all co-organizers of this event. It's really a pleasure and honor to be here with all of you and all participants. As Anna said, my job today is to present some highlights of the report that Open Society Justice Initiative just published this month, 2 weeks ago, where with INSCOT present here, we looked into the experience of 15 independent investigative agencies and prosecutorial departments around the world. We looked into the experiences of Indocom in Jamaica, and of course, very known Police Ombudsman of Northern Ireland, and the agencies in Kenya, South Africa, Trinidad and Tobago, Republic of Georgia, prosecutorial departments in Ukraine and Argentina, and now disbanded department in Rio de Janeiro. So it's really a wide geographic coverage, which was very exciting to do. And thanks to all our interlocutors, without whom we could never do it, to understand the local realities. Our focus is on criminal investigations. And we understand that criminal is only a small part of the achieving accountable law enforcement. Of course, we need overall rethink of the role of police in our societies and continue to rethink it. There needs to be internal controls, monitoring of use of force, disciplinary measures, general oversight. We understand it's a small part, but it's an indispensable part. The movement today, very much in the United States, where ambassadors say his name, it's also we need to call the actions by their names. It's some of the actions of the state agents that are mandated by us, by society, by law to protect us, might amount to crimes, to serious crimes. They should be investigated as such and not as misconduct or abuse or anything else. And that's something that probably is a very important message and statement. We've seen in the last years, in the recent years, that actually this understanding is there, and the new agencies. We really see that some of the agencies are 30 years old, and there are those that are 2 years old, and that field is developing. In our report, we offer a set of 10 groups of recommendations. They're dense, very technical. I'll not go through all of them, but we hope that they will help the policymakers and practitioners and activists who are either trying to help set up new agencies or strengthen existing one, to learn from other experiences to avoid some of the pitfalls. We are struggling to have this recommendation specific enough to be useful. But we also understand, even if these agencies should be independent from the police, they're part of criminal justice system of each country. They are part of each society, and each context is unique, so you cannot create a blueprint. Also, in reflecting on the report and on the recommendations, we really are trying to balance what I would call political and technical. We know there is no technical solution to political problem. If the society and the government decide to turn blind eye, you can create the best investigative agencies, and there'll be enough other laws and lack of cooperation and everything else that it just will not be possible to work. But at the same time, unlike like human rights cases, which I'm used to work all my, like many years of my practice, to convict somebody in a fair trial of a serious crime like a homicide, you need a lot of technical tools and knowledge. You cannot do it by just like expression of like the political decision to do so. So our recommendations really, I hope, go between this political and technical. We start with independence. These agencies need to be independent from the police as much as possible, as they're part of criminal justice system. We think that should be separate legislation. They need their own budget. They need their own physical facility. And to at least try to be free from police culture, we strongly recommend for the director to not have ever served as police or another state agent. We speak about independence of the leadership, that basically, like similarly to recommendation of the police ombudsman in Northern Ireland, that guarantees of independence for the director should be similar to an ombudsperson. You need a public process with participation of different actors in society, appointment, but what we say legislature, but again, we always come back that each context is different. Guarantees from early dismissal, fixed term, and also the responsibility, I think of which probably we'll speak a bit more later. Who takes the decision to charge? We would recommend that it should be the director. But again, many constitutions say it's only the prosecutors who can do it. You just cannot change it. Then you need a set of very clear, like, rules of interaction between the agency and the prosecutorial service of reporting back to the director. And coming back to public trust, asking the director to probably to report back to the public on the decisions not to charge, which are much harder. In Scott probably will speak about it. That not charging is easier. It will go to trial. But like, how do we interact with public when the decision is not to proceed? Because we remember, police is allowed to use force. We recommend that investigators should be in majority not the former police. But you need, again, it's homicide. You need some former police, probably, especially in the beginning, to have technical knowledge. So you notice that in England and Wales, the agency has like 12 to 18 months training program to allow what I'll call civilian investigators to get necessary knowledge. Indicom in Jamaica also trains its own scene examiners, and so on. But then you move to technical. You really, again, to investigate homicide, you need access to crime scene. Indicom in Jamaica access all crime scenes involving police, all shootings, but it's a small country. It comes back to the number of officers to train staff and so on. You go into all these details that you need to segregate officers. You need to have rules based on fair trial guarantees, which notes you can or cannot access. How will you get evidence? Will the police turn their cameras to the investigative agency? How do you have access to forensic examinations? How independent they are? Can you challenge them, and so on? So this balance of like nitty-gritty is actually critical for investigation to be successful. Any criminal investigation is difficult. And here's Helena was speaking, you're going against what is called blue code of silence. Those who normally have access to this evidence will not easily just bring it to you. And the last thing that I would say, what we struggled with is the jurisdiction. Because on one hand, you want it to be limited, right? You can't say all crimes by the police, the agency will be overwhelmed and police will do nothing. But how do you define the most serious crimes is hard. So we recommend, after a lot of debate, two sets of approaches. One is incidents, any death or serious injury. It might be completely legal, but the agency should look at it. And then all allegations of torture, sexual assault, or enforced disappearance. Because police will not report those allegations, right? You need to get them from the public. We know that agencies are not a cure-all. Again, accountable law enforcement demands much more. But I think we've seen from 15 experiences around the world that if they establish properly, they can start holding police accountable. This respect of fair trial often involves police who do difficult work of like ensuring security of society, bringing more justice to the victims, victims' participation of public defenders' offices, civil society. And at the end, that leads to also bigger public trust and just society that we live in. Thank you.
Thank you, Masha. Thank you so much. I think you really did well in the challenge to summarize all this work in a very short time. But we're not finished, so that's good. We will hear now from two more experts who will tell us more about independent oversight bodies and investigation bodies in the police, on policing rather, sorry. So we have now Ms. Tamar Zubashvili, who is from the State Inspector Service from the Republic of Georgia, and Mr. Ian Scott, who is an Ontario lawyer, and the former director of the province's Special Investigations Unit in Canada, and who is also the co-author of the report with Masha. Welcome, Tamar and Ian. Nice to see you. I will ask you a few questions, and then we will go to the few minutes of questions from the public. I know we're really stretched on time in these events. I don't know. Someone decided 50 minutes was a good timing, and I think it's very short. So first of all, Tamar and Ian, maybe we can start with Tamar. According to you, what are the key preconditions, normative, technical, political, for an independent investigative agency to work effectively in your context? Sorry, Tamar, please.
Good afternoon. Thank you, Anna. I would like to start with expressing my gratitude for inviting the State Inspector Service. It is my pleasure and honor to speak at today's event on behalf of the State Inspector Service of Georgia. With respect to the questions posed by you, I was listening to Masha's report, and I've read this report, and it's very interesting. And you'll find some parallels in my speech as well. To start with the legislative preconditions, of course, this is the first thing that the independent investigative agency should enjoy high degree of independence, institutional independence. And this independence should be guaranteed, first of all, at legislative level. For example, in our case, when we speak about independence, the State Inspector Service of Georgia is an independent institution and is accountable solely to the Parliament of Georgia. However, in the process of investigation, to an important degree and extent, it depends on the prosecutor service because the prosecution service conducts procedural supervision over investigation. If we turn to the technical preconditions, then of course such an agency should have strong and professional investigators as well as infrastructure. And I will also speak about the example of the State Inspector Service. Until now, we had 2 offices functioning throughout the whole country, which made it impossible to cover all the regions. And due to the fact that we have a small number of investigators who have to travel on a daily basis to regions in order to conduct investigative actions, which sometimes delays the process of investigation and obtaining relevant evidence. Therefore, it is very important to have qualified staff, relevant infrastructure, including offices. And Masha was also speaking about dependence on police. For example, in our case, we do have our crime scene examiners. However, for a certain period, they did not have special equipment, for example, for collecting samples, evidence, and we had to rely on the evidence collected on the crime scene examiners of police. So this, of course, creates some sort of dependence on police as well. And if we turn to political part, I think this is the most important part, that there should be political will and that the mechanism to investigate ill-treatment cases is effective, which as well includes equipping these type of agencies with financial resources, human resources, etc.
Thank you so much, Tamar. Ian, would you like to add, maybe from your long-standing experience, what are the key preconditions? Sorry, it's going to work one time.
Oh, no, thank you very much, and thank you very much for inviting me. It was a journey to do this paper with Masha, because it allowed me to have a much more international perspective of some of these issues. And frankly, many of the points that I was going to mention have already been covered. So I want to focus on two rather specific points here, which I think are very important preconditions. One is the relationship between the investigative agency and the prosecution service, and the other is the decision to charge and not charge. Now, these to me are two critical issues. The way the Special Investigations Unit in Ontario is set up, the director, and I was a director for 5 years, made the decision to charge or not charge. Now, the reality of any of these agencies is the vast majority of investigations are not going to lead to criminal charges. In my view, this is the most difficult job for an IIA, an independent investigation agency, to grapple with. The reason being, as Masha alluded to, if it goes to trial, there will be a public accounting, ideally in a public courtroom in a fair trial context. If no charge is laid, the real question is, how is there going to be public accountability? And the SIU struggled with this for a long time. And after about 30 years, it now releases full reports on all of the no charge cases except sexual assaults because of issues of confidentiality and privacy. Now, the public reaction to this is not necessarily good. We're never going to get a consensus on many of these areas when excessive and lethal use of force is used. But at least the agency can say there is a form of accounting. And one of the things we ran into was, for example, in South Africa, the independent agency there gives its briefs to the prosecution service, and it seems to disappear into a miasma. There's no answer. They just go away. So there's no accountability because there, as I mentioned, there will not be that many criminal charges laid. So I think this is a critical issue in terms of public confidence and public accountability. So these two issues go together, the charged, non-charged decision and the relationship between the agency and the prosecution service. One way or the other, there has to be a public accountability. Thank you.
Thank you. Very important points. Thank you so much. And I see we have several questions in the chat, but I'll still finish with mine and then we can go to the chat. For us, we can go over time. I know Candice has to leave, but others, please, we can stay on after 2 o'clock. So thank you. And thank you, Candice. I know if in case you leave, we know that you have professional reasons to do so. I know you're very interested in the subject matter. So this second question would be, and you touched already upon it a little bit, what are some of the main challenges you have faced in your work and in the work of the State Inspector Service, Tamar?
Yes, the major challenge relates to legislation. And I already mentioned that the State Inspector Service and the course of investigation depends on the prosecutor service. And what I meant is that an investigator of the State Inspector Service is not authorized to make important decisions with respect to conduct of very important investigative actions, such as seizure, search, request for medical documentation, footage of CCTV cameras. Moreover, the investigator of the State Inspector Service cannot independently make a decision to request video recordings even when there is a danger that the evidence might be destroyed. And in this case, we need to obtain a prosecutor's resolution. The requirement to obtain prosecutor's consent in all important investigative actions limits the ability of the State Inspector Service to conduct in the investigation independently and hinders the independent determination of its direction, timely conduct of investigative and procedural actions, which are necessary for effective investigation and collection of evidence. Another legislative challenge is that the mandate of the State Inspector Service also extends to crimes committed in penitentiary institutions and temporary detention as isolators. And according to legislation, we don't have the right, without consent of such establishments, without consent of heads of such establishments, to enter them, which sometimes causes delays. For example, permission to enter these institutions sometimes takes up to several hours or entire day. And in these cases, when there is ill treatment case or death, unexpected death, of course, these delays obtaining relevant evidence, which is crucial to obtain in the first hours of investigation. Another legislative challenge relates to crimes to overlap between crimes that fall under the jurisdiction of the State Inspector Service. For example, we investigate exceeding official power with violence, and we investigate inhuman and degrading treatment. And sometimes it's difficult to differentiate between these articles. And of course, it's better to start with lex specialis, but due to the fact that there are some similarities, it's not always easy to differentiate. Another legislative challenge is that, not legislative, but yes, another challenge relates to awareness raising. For example, due to the fact that the State Inspector Service is a newly established institution, awareness with respect to its activities is low, and quite often alleged victims turn to the same agency and employee of which can be implicated in a crime rather to the State Inspector Service itself, which again delays conduct of investigative actions. I already mentioned infrastructure and human resources, and I will not draw your attention to this again. And one of the challenges, which is characteristic to our service because it's a newly established institution, and due to the fact that coronavirus, following coronavirus outbreak, we didn't have a chance to communicate and build communication and cooperation network with our foreign counterparts. We wanted to share best practices and experience, and in this regard, we're also hindered from this. This was very shortly. We have quite a lot of challenges which are reflected in our report, but since we don't have much time, this was very shortly about major challenges.
Thank you so much. And what I'm hearing both from Ian and from you is really this important link to the prosecution and how to ensure that that works well and that prosecutors do prosecute when necessary, and also these powers that you need. It's true that other examples like Indicom, as you said, Masha, have very strong powers in terms of crime scene investigation, for instance. And of course, yes, the aspect of international cooperation as well. Ian, do you want to add something in terms of additional challenges that you had to overcome?
Well, one never knows if one completely overcomes them, but let me give you one example. Written into the Ontario legislation is what's called a duty to cooperate. Rather straightforward. All involved officers with a bunch of conditions have a duty to cooperate. So when I became the director of the SIU, Special Investigations Unit, it had been in operation about 20 years. One of the things I found when I got there was that there was one police union lawyer going to the scene and advising all of the involved officers before they wrote up their notes. Now, the officers were cooperating. They were writing up their notes. They were giving them to the SIU investigators, and then they were going to their, except for the subject officer, to their compelled interviews. These are compelled interviews. They have to be interviewed by the investigators. But what was this doing? This was undermining the integrity of the independence and credibility of the notes, because all lawyers know that you have a duty to share information among jointly retained clients. I tried to get some traction on this. I went to my political masters. I went to senior police officers, and I basically just got blown off. So I found my best friend actually was the media. When I wrote up my reports as to reasons why charges were not laid in press releases, and release them. I would put this information in the press release. Well, a family of a fellow who was shot by the police picked up on this. There was a court action, which we actually document in the paper, which went to our Supreme Court of Canada and found that this practice was wrong. Now the notes have to be written up independently without anyone involved in those notes. And, you know, these investigations are not that different than many other investigations. What it really boils down to is you want to have information and data that you can rely upon in court. And if you don't have social media, you don't have body-worn cameras, really statements become critical. Statements and forensics are really what these cases are all about. Thank you.
Thank you. Thank you so much, Ian. I think those are really important points, in particular on the role of the police unions and the lawyers. Final question from us to each of you. Maybe we can start with you, Ian, now. Do you have one recommendation for a country that is planning to establish a new independent investigative agency?
Well, we don't have much time, so I think this is rather easy for me, given the fact that our paper is literally hot off the press. Please read our paper. There's 10 recommendations in it. I cannot pick one over the other because there's an interrelationship among them. You can have the best legislation in the world. If you're not well funded, it doesn't matter. If you don't have good investigators, it doesn't matter. If you don't report back to the public, it doesn't matter. So there's a synergy, there's an interrelationship, and I recommend, at the risk of sounding immodest on my behalf and Masha's, read the paper.
Thank you. We will certainly read it and reread it. Tamar, from your experience of a quite recent institution, what would be your key recommendation?
Our key recommendations, based on our practice as well, would be first of all to adopt such a legislation which will ensure high degree of independence and clear delineation between prosecutor service and investigation, so that the investigation could take all decisions concerning important investigative actions. I don't have one recommendations, actually. I will agree with Jan that it's very important to have highly qualified investigators and to have enough number of qualified investigators, because in our case, we do have qualified investigators. However, they can't handle the backlog, the workload of criminal cases. Lastly, last but not least, it's very important to speak about challenges openly. From the very first day of establishment, the State Inspector Service, in its annual reports before Parliament, on the meetings with international organizations and non-governmental organizations, we always speak about our challenges, because if you only speak about progress, you'll never advance. I think this is the first step that you should start with, to speak openly about challenges. Thank you.
Thank you. Thank you so much. Both your points were really important, and I think this reporting on the challenges and not only trying to show that you're doing a good job is really important. I'm going to go to the questions in the chat. I've seen the first one was addressed to Masha. I think it has been partially responded to. It's basically about civil law countries, but I understand we have, Georgia is, I imagine, a civil law country, if I'm not wrong, and you do have an independent oversight investigation agency. So I think we have moved away from this sort of only common law countries have independent oversight institutions. But Masha, do you want to add something on this point, both on the civil law countries and on the role of the prosecutors' offices?
Yeah, I think Tamar covered it a lot. Basically, it's not just civil law, right? It's each country. You look into this like procedural guidance, right, that Georgia or Ukraine has. In Argentina or Rio de Janeiro that we studied, it's inside prosecutor's office, but this specialized department of prosecutor office needs the referral of the regular prosecutor to take the case. So we can go on and it's basically trying what you can in your constitutional, you are limited by the constitution, to have some continuity and cooperation from the moment of crime scene or incident scene, right, to the prosecution. and it never will be perfect, and there will be big role of prosecutorial service. But where it flips, right, it's like which is bigger, it's really like even it's not just common and civil law, it's really inside each country. Even like if prosecutors in this country have public trust, right? In Latin America, we hear a lot, like we actually probably trust prosecutors better than anybody else. Maybe you can do prosecutorial departments, but how do they do investigation? In some of like other countries, it's really a no-no. So like I'll stop here and maybe when Tamar answers the question.
Thank you. Do you want to add something, Tamar, on this point? Or anyone else?
Well, oh, sorry, go ahead, please.
Or go ahead, Tamar.
No, actually, I didn't have much to add to, yes, so what Masha said, yeah. It was a long-standing recommendation from international organizations and non-governmental organizations to establish such an institution that would fight ill treatment effectively. And yes, finally, this type of institution was established. And what's important that we know what expectations toward this institution are. And yes, what I forgot to say, it's very important to gain public trust, and we're pretty much working in this direction as well.
Thank you. Ian, do you want to add something on this point?
Oh, well, very, very briefly, it was an educational experience for me to see some of the major differences between common law countries and civil law countries with respect to both investigations and particularly the role of civil society and the role of families of the deceased or aggrieved families in the criminal justice system. We expect it in the civil, but in the criminal, it was remarkable for me to hear about families and their lawyers actually having standing in criminal courts. Virtually unheard of in the common law system, where it's very much a relationship between the state and the individual. Whereas I think in civil law countries, there's much more input from the families and equally remarkably, non-governmental organizations. We just have a different tradition in this regard.
Yes, thank you. I totally agree with you. And I think there's something to learn between each system, but also between different countries that have, differences in the legal systems. Yes. The next question is from our colleague Neil Walsh, who is the head of our money laundering and cybercrime section. Neil is asking if you still see a role for internal policing or counter-corruption units, or should all allegations be undertaken independently? Masha, do you want to go first?
We have the same answers for always saying it's context specific, right? In some, like in Norway, for example, the agency has corruption, and many of the cases its reports have corruption. In Ukraine, there is a difference between like investigations, like sort of more petty corruption will go to one agency, higher level corruption will go to another specialized agency. I think, and some could be internal, right? Like some basic behavior of police, the police should address internally. You don't want to outsource all discipline and controls. The police also just go, like we heard it in South Africa. Police do anything, just say, oh, just go to the investigative agencies. They deal with everything instead of taking responsibility. So of course there is a role for internal. That's why we say it should be exclusive jurisdiction. We suggested some, but it's context specific. And the rest need to be addressed based on the practices of this country and what might work.
Thank you. Does anyone else want to comment on this point?
Perhaps Ambassador Dinson, I see.
Thank you so much, Jan. No, actually, it's not specifically on this point, but since I have to attend another meeting, I just wanted to provide one more comment. Namely that, I think I've heard so many interesting things here from all of you, not least from Masha, of course, but from all of you. And, the fact that we should look at challenges, not just praising what we have done wrong is so right. And I have been thinking constantly when you've been talking about, okay, in our Danish system that we are so proud of, are those people really former police officers or what? I've certainly taken a lot of notes I would like to go back and look into. So this is not easy for any of us. And I think you're absolutely right. We have to come to terms with that and be very honest about that. My second point would be that I think that the way we interact right now, where people who either work as in the UNODC with actually helping countries get more capacity on this area, academia, researchers, people like you that are also practitioners, and then people like me who honestly do not have their fingers in the details, but are more involved in, let's say, the normative part of it. I think it's so important that we actually speak together, and I think we could learn so much from each other. So the part that I know much about is, of course, the normative, the global aspects, and I really hope that events like these will help you that are closer to the actual events and the decision makers to try to connect the dots, to try to use as much as possible those hard-fought small gains we get in the normative political discourse. So make sure to make your governments responsible and remind them of what they have actually committed to in Vienna or New York or Geneva or elsewhere. So really make good use of these things. And likewise, of course, we need it to be a two-way street. So I will certainly also pick up from your experiences. So I really think there's a two-way street here. And then with development and capacity building being the third leg, where, for instance, a country like Denmark, but it could be many others as well, and of course UNODC is centrally placed there, and many very, very professional NGOs. The exciting triangle is when we actually get the normative global political sphere to work together with practitioners, and that those of us that provide the 0.7% of GDP in development assistance, we actually gear or steer some of our funding to help with capacity building in countries willing and able to take responsibility from the global norm setting. So too many words just to say, for me, thank you very much. It has been very inspiring and hopefully not the last time we get together like this. Thank you very much.
Thank you. Thank you again, Ambassador. I think it was really important what you just said. And this is really what we're trying to achieve here in this event. We're the only, I would say, positive outcome of this latest COVID pandemic and so on is that we can all be together online and in a public forum. At the Crime Commission, we used to have these side events in rooms that were closed only for delegates and, of course, civil society. So I think we should take that as an opportunity as well to have a broader discussion with all that have something to say on this issue. So thank you again. We will still finish with our questions, but thanks for being here for the whole event. So we were on the Neil's question has been answered. I think from my point of view, I would agree with Masha that and this is what we at least said, we keep saying that you need both internal and external bodies, because the external and independent bodies will most of the time deal with the more serious cases, while the internal bodies can also impact on revising internal policies. And there's it's just like accountability in any organization. It's important that this is taken as a responsibility of the actor itself. So it's not only seen as something that these other people are doing that are a little bit annoying because they disturb us when we're doing our work, but it should also be seen as an important role for every civil servant to have integrity, accountability, and to be ready to respond for their acts. And codes of conduct, internal oversight, investigation bodies are also important, I think, in this area. There is a specific question from the Omega Foundation, which is also an important partner on use of force issues. I've seen there's also a new report from Omega Foundation that I'm planning to read. But the question is the following: law enforcement agencies often evade oversight regarding the unlawful use of force due to a lack of technical knowledge around police and security equipment and techniques among legal professionals. This is compounded by a lack of transparency regarding authorized tactical options and associated risks. What kind of training do independent oversight bodies tend to receive on these topics? Maybe Tamar, would you like to start answering?
Well, if I understood correctly, this is also one of the challenges in our country, for example, that the police, they don't have these clear standard operating procedures with respect to the use of force. And for us, we confront with the difficulties to discern when the proportionate use of force went beyond the proportionate and when it became illegal. So in this respect, we didn't have any trainings, but we are now studying best practices with an invited expert who is conducting the research in this respect, how to deal with this type of issues. If I replied correctly, if not, then I can elaborate more maybe.
I think the question is also aiming at whether investigators are trained on different instruments of force, how to use them, you know, if whatever the police has as instruments of force in your country, could be taser, could be baton, could be firearms. So are the, you know, investigators also trained in these kind of technical and tactical use of force issues, if I understood correctly?
There are several trainings that are routinely conducted for our investigators. This refers to investigators of the independent investigative agencies, right? And for example, now these days they have training on crime scene examination, and we plan. They did not receive any training until now, but yes, we plan to conduct training for our investigators how they should use force with respect to these various means, which is also challenging in our context as well.
Thank you. Thanks so much. Ian, would you like to comment on this?
Yes, this is a very difficult issue because what the independent investigators are doing in their investigations is in the larger scheme of police, very esoteric. All police officers are trained to use for the use of force. At least in Ontario, they're given annual updates with firearms training. But this is really how to use it in a very technical way. But what we do in Ontario is there are internal training sessions. Investigators are sent on courses at the police college where I don't think they get invited to a lot of dinners when they're there, but they indeed go to these courses and learn about the training that the regular patrol officers would receive. But there's about only one unit I can think of all of North America, which is in the States, which is a fellow who specializes in giving expert evidence of use of force. And he's generally viewed as somebody who is an apologist for the police. So his value, I think, is rather limited at a more objective level. I mean, at the end of the day, this is what these agencies do, actually, in the area of use of force, is determine what's reasonable, or at least make a decision as to whether something should go to trial on reasonable versus excessive. And the line can be a difficult one. The line can be one that turns on nuance. These situations are often very dynamic. And I guess that's why you have directors who try to assess the evidence and make the call as to what goes to trial.
Thank you. Thank you. Masha, do you want to add something on this point? No. Okay. Thank you. So we have one more question, and I think then we will close. So the question is on, on the basically militarization of the police. So in attempting to reduce excessive use of force by police, how much importance should be given to engaging police forces and how much to governments? Police forces in some countries or cities affected by criminal violence often have a propensity for use of force, but often that behavior is encouraged by governments, and the example being the mano dura in Central America. Maybe Helena, do you want to comment on this, or anyone else?
Yeah, sure. happily comment, as it was and it is my area of, that I follow more closely, Latin America. I think that to reduce heavy-handed practices, we need obviously a shift from overuse of force to more human rights compliant practices. And I think that this is only possible with police reforms. I know that this sounds, it might be abstract or long term, but I think there are already measures that can already, be put in place, which involve, of course, these police like reform processes, the highest instances of government, so that it triggers down. So then consensus should be built involving also a wide array of actors in these countries, like CSOs, academics, but also I think it's important to see how to prevent the criminalization of the poor. And I know that there was also a side event on the margins of this session on precisely this. And at the same time, I think it's also a clear tendency to criminalize the poor, but also now we see it in Colombia or in many other countries, like protesters. So anyone who dissents basically is the target of use of force. And I think this vision of protesters as the enemies that also prompts the militarization of these countries. And just a last point, I think in Honduras, for instance, I know that there was, after the electoral crisis in 2017, the OHR office there and civil society organizations managed to push for a new law on the use of force, so that at least, that's more short term, to have legislation that can regulate and embed the principles on the use of force. But I think that has not been actually, followed through. But of course, the Committee Against Torture recommends, a wide array of measures, including also legislative changes, to precisely avoid this this question presents, and this of course comes from the government and the three branches of power, actually, that they should be articulated on this, so that this is really something integral. And just like one comment, many thanks, since it will probably be my last words. Me and my colleagues, because I'm getting messages, we learned a lot and plan on sharing also the best practices shared with our network, so that they can also push their governments to go in this direction. And I hope we meet again in person as well, in Vienna or elsewhere, and also virtually, so that we can take this discussion further. Thank you very much.
Thank you so much, Helena. And I just wanted to comment on this last question, and I know we need to wrap up now, but I totally agree with you. And this is also our approach to work on, broader police reform, which we know takes time, requires engagement of everyone. So both governments and the police. You need police itself to be involved. You need managers, middle managers that believe in reform. It cannot just come from the outside, whether it's a government or independent oversight body that says you need to reform. You need to have agents of change also within the police. And I agree with you. I think that there is a new wave somehow of police reform in a number of countries. In fact, in particular in Latin America, we have engaged, for instance, now with the Dominican Republic that is launching a new process of reform. I think there are similar discussions in other countries, and not only in Latin America, in many parts of the world. I think we have to be patient. It takes time, because changing police culture and changing institutions and approaches from from a kind of militarized approach in some places, or very strong colonial mindset in other places, which is something our expert from Mauritius mentioned also the other day when he spoke on police reform, towards a service-oriented, police service and not force. It takes time, but the use of force aspect cannot be the only one. It's within that broader context. We've done quite a lot of work with OHCHR on this area. So again, you can have a look in the menu of services that Michaela shared. There is a link to all our publications as well for those who want to know more about the use of force, which we didn't really go into in this event. Maybe Ian, or do you have any last words before we close? And then I'll go to the two other speakers. You are on mute now, which is...
No, very, very briefly, we've talked quite a while here, but this question really touches upon two models of policing. At the one end, we have the Peelian model coming out of England, which is the 19th century of the public being the police and the police being the public at one extreme. And the other extreme, we have basically the occupying army model. And the more we slide towards the occupying army or the militarization, my view would be, this is a bit anecdotal, but the less likely oversight will work. It will polarize the community. There will be many members of the community which will rationalize the excessive use of force in the occupying army, highly polarized, highly unequal societies. And to some degree, there's only so much we can do with the IIAs, which we've advocated in the paper.
Thank you so much. Tamara, do you want to say anything more, or just thank you from us?
Yes, I will just say thank you once again. Thank you very much for giving us the possibility. I really believe that this type of events contribute to developing independent investigative agencies and to, in a broader sense, to fight against ill treatment. Thank you.
Thank you so much for being with us. Masha, you would have the last words. Masha is really the brain behind this event. I had half a brain as well in it, but thank you so much for initiating this. I think for me, it's just the beginning of a really strong and even stronger partnership with some of you that we've already been working with, and we are definitely, let's say, our programming in this area and our work in this area has been getting much more attention in the last year. So I'm hoping we will be working all together. But Masha, I'll give you the last words. Thank you.
Thank you, Anna. And I think the question was answered. I also will just thank all of you and say, you know, for me, and both with our report and OMCT's report, you know, I don't want to speak for Helen and colleagues, but for me, I stepped a lot out of my comfort zone. Like, I'm a human rights lawyer, right? I know the standards and I know what's right and wrong. And I can argue a standard in the case or in a report. But here we are making choices, right? Here we are trying to get into the how. And the how, this is what Ambassador was speaking about, right? The area of policymakers, the politicians, is not that like natural for me. So I'm very thankful to Ian for walking this journey with me, and for Tamar and all others who shared the interviews, but also to MCT and Anna, UNODC, because I learned a lot from you, and I see how we all try to get into this like practical realm, right? How we can walk the talk, right? How can we make these principles and rights and standards that we are deeply committed to try to work? And I think that what OMCT's report is doing for the use of force on like what it is, right? That's what our report attempts to do on how. And I agree with everybody, it's just the beginning of conversation, right? Even our 95-page paper, some of us notes, so don't get scared. It's really just the beginning of starting to discuss.
Thank you so much, Masha, and thank you to also our colleagues from advocacy who have been active on Twitter for us, and all the participants. We still have 32 people connected, so thank you all for staying with us for longer than planned, and we are at your disposal for follow-up. Thank you so much. Have a nice weekend.